in a farm where there's a solo practitioner,
yes.
how does this, how this medical emergency policy is structured?
Okay.
Because my understanding is the moment a solo practitioner passes, we need to nominate the advocate to take over. What happens? How do we structure this medical emergency policy?
Okay. Maybe I was not very clear, but I was discussing the medical aspect and a policy termed as an emergency preparedness policy. And if you might remember, then I went on to cite a few examples of the emergencies that you'd have in an office. So I started by mentioning fire as an emergency. Then I talked about medical as an emergency. Now, the policy document talks about 3 steps. I think I mentioned one only. So under medical emergencies, it says immediately call, a particular service provider for a serious medical incident. But then I get your question because you're saying this is a solo practitioner. This is someone who is all alone in the office. They get a medical emergency that they are not able to handle on the spot. What will be, what will be the way out of such a situation? I must admit that it can be a very unfortunate situation. And of course, not oblivious of the fact that we have had a colleague succumb, while attending a court session, and he was all alone. So I really don't know how, Karen, will you have another alternative? Or anyone from the audience who can give us a leeway to that, like a solution to what will be your, what will be your medical emergency preparedness in a situation whereby you are all alone.
I think one of the quagmires we have here is we've had a real life case, like you've explained,
Yeah.
a senior mentor who collapsed, and the immediate action that could be done was he said to rush into his side and the like and calling for an ambulance, but unfortunately, as we very well know, he was pronounced dead on arrival and nothing could have been done in that situation. I wouldn't have an idea, but I also want to introduce something different, which we discussed with you before, but just to pick your thought on it. Part of the other question would be, as a sole practitioner, because I am one, every year when I'm taking out my PC, I'm required to nominate someone that in the event of a demise happening to me, they'd have to take up my cases. Now my question in this case would be, we've had such a debate, is it taking up the files that I have for purposes of closing them or for taking them up as their lawyer? Because there's also that particular, there's a very thin thread about what you're supposed to do. So I would want clarity if you have, and even from the audience. Also, I note that we do not have any hands raised. Please take this opportunity. We still have a couple of minutes that we can accord any person who has a burning question. So feel free to raise your question, your hand if you have any question. Wamboi, we are still deliberating about your question even as we're having this particular conversation. So in those circumstances where you don't have a partner or set of partners and you're in a sole proprietorship situation, what happens? Please feel free to weigh in. Just raise your hand and mute your mic and go right ahead.
Actually, Karen, I appreciate that this question has actually morphed, because that's the other issue. When we die and we are solo practitioners, how do these nominated advocates take over our matters?
Thank you.
I'm actually glad it is morphing. Thank you so much.
You're welcome. And I can see we have a very senior practitioner here who, first of all, I have to say congratulations to. But Mary Sheila Sige, please go right ahead and assist us in answering this question. And congratulations again. We are the young ladies who are watching and celebrating you on the sidelines.
Thank you. First, I have to apologize. My background is very noisy because I am not at the office. But I'm going to answer that question with experiences. So, luckily for for where I practice, we are many lawyers, but I have colleagues who are friends. And for example, for sole lady practitioners, when you go on maternity leave, you do prepare by asking either a lawyer that you trust to come in and run the firm basically, or handle your briefs. And you start from, because then it's something that you expect. So you start having those discussions and having them familiarize with your clients, how your office works early enough, then they are able to do that. I know of ladies who've been able to do that. I can give an example of what we did as family law practitioners when we unfortunately lost Judith Ogori in January this year. So while we had the benefit of coming together for about 2 weeks, so what we did is we created a roster as family law practitioners, and every day, because the lawyers at our firm were then not mentally or emotionally able to proceed with the matters for a while, if you're on that roster, you would have a roster where you go and do client attendances from the firm. We would have a roster where you take matters in court and you see the ones you can proceed with and the ones you need to adjourn, including the service. So there's not any single day there was somebody actually, the Korean company, who was not able to proceed. I think you gave the answer of why you have to think about how you fill in your form at the end of every year and who you nominate if you're a sole practitioner. So I can give an example of a lawyer who died and was a classmate to one of the senior partners in the firm. But he had, I don't know if he had not nominated somebody or whatever it is that happened. So what happened is, because his wife was also a lawyer, she then came to ask us, what can we do? And we told her, go and speak to LSK. And LSK was graceful enough and said, because she trusts us, then 2 of us at the firm, myself and Mr. Ching, were appointed as trustees. And we then were able to hold her hand and then just run the farm for a while until she decided what to do with it. But I think also, when you have such forums, the importance is we then get to connect, we network. So you then start having those discussions. Have your secretary, your people, your clerks in the farm know that on the day that you're very sick, you can't be found, or if you have an emergency in the middle of court, like we were talking about one of our colleagues that we had last year, then they can quickly reach out to one of those lawyers and say, we have this matter, the boss is not there, please just attend court and do whatever you can, or reach out to the other lawyers. So my examples are just from experience and what I have seen happens in practice. Thank you.
Thank you, Senior. And just before you even disappear, I just have a question for you. Just within that confine, what exactly happens? For me, I just want to understand, if today I'm to die and the nominated person, of course, takes over my matters, are they just meant to wind up my matters, or are they meant to just take them up and run as if they were their matters? Because we've had such a huge debate on that particular issue, and I like that you've experienced real life examples, so it's easier for you to just say, this is what happened. And I like the idea of trusteeship that you've introduced, because that's also something important and fundamental for us. So before you disappear, please address that, and then you can have closing remarks if there's no other question. Thank you.
I think if you're a sole practitioner, then it ultimately depends on your dependents and what they want. So if your dependents, obviously you will have to have whoever it is who is nominated to move the court, the succession court, as quickly as possible and get a limited grant. And with that limited grant, you want to start running the firm if there's issues of access to bank accounts, so that you can pay the basic overhead, salaries, rent, and the ones that can't wait, you do such things, and even continue receiving monies from clients. That's what they would initially do. And then you would then have discussions of it is who has been nominated and the dependents of the deceased advocate on what can be done. And what can be done will depend on if you then are able to come up with some sort of books and accounts. What's the status of the client account? What's the status of the office account? What are the pending payments and obligations? Does it then make sense to then bring someone to take over the firm, or does it make sense to wind it up? It's a business decision. You would have to assess all those things and then decide what to do.
Thank you very much. Allow me to now just hand over to Senior to give his closing remarks, and then I'll take over and make important announcements. So if you're about to leave, just wait. There's still a bit of suspense that is still hanging in the air because there's a book that's coming up. So what are the dates? When are the pre-orders supposed to be done? These are very important announcements that I need to make towards the end. But let Senior just give us closing remarks. Thank you very much.
Perhaps just as we fold up, and in respect of what Council Mary Sheila mentioned, there was that particular aspect of letters ad litem. Those letters of ad litem, more often than not, are normally applied for in instances where the person nominated to take over, the person nominated as the, what's the term again for the person who has taken over? Okay, for the person who's been nominated, instances where there is a challenge in executing the mandate of, let me call that person a trustee. I have encountered 2 or 3 practical instances, once as a council member, and 2 of them outside of council. And the elaborate mechanisms to ensure that a firm of a departed colleague does not hang in abeyance in terms of execution of the matters. Now, the Practice Standards and Ethics Committee, and I believe ABA also, will also midwife the process of transitioning that particular firm to either the person who's nominated, because you reckon that also the person who's nominated might also have incapacity to handle, the cases. One particular instance I had was that our colleague was also married to an advocate, but the advocate was, a state officer. So whereas the spouse had got all the capacity to handle or take over the farm, they couldn't do that. Then LSK is called upon to nominate on behalf of that particular person. But just in summary, though I did not mention it, there's an elaborate policy on succession and business continuity plan, which I hope at the right time we will all benefit from having a look at what it provides.